Hi everyone. We're delighted to be presenting to you today. As Talisha said, my name is Richard. I'm a solicitor in William Fry, and I'm joined by Ronan Shaughnessy, who's a trainee on our team. And we're going to give you an overview of, I suppose, the statutory employment entitlements that we would quite often see come across our desk on the daily. So there's a broad range of employment legislation out there. There's, I suppose, a variety of sources. Some of it comes via the Irish government, whether that's an act or a statutory instrument. And also there's European legislation that, we would then transpose into Irish law. So we obviously won't be able to cover all of them today, but as I said, we're going to cover the main ones so that we see on our desk. So here's the agenda. So Ronan's going to run you through the statutory entitlements in relation to the employment contract. Ronan's also going to look at the national minimum wage and the living wage. I'm then going to look at working time, annual leave and public holiday entitlements. I'll also look at employment equality and the dismissal framework in Ireland. And then finally, I'll give a brief overview of avenues to address workplace issues, complaints or disputes. I'm sorry, I have a bit of a cold, so I may cough now and again, so I hope you pardon that interruption. But before I pass over to Ronan, I'd just like to ask if you could hold your questions to the end. You can pop them into the chat box or hold them for yourself. But yeah, we'd like to kind of run through the slides first, and then we can hopefully address any questions that you have at the end. So without further ado, I'll pass over to Ronan, and yeah, we'll move on to the employment contract.
Hi everybody. So I'm going to first of all run you through the employment contract. So in terms of what is an employment contract, your contract sets out the rights and responsibilities for you and your employer. The terms of your contract can be express or they can be implied. So if your contract terms are express, that means they are set out in writing or provided to you verbally. Whereas if your contract terms are implied, that means they have not been set out, but they still apply. For instance, that every employee must do their job to the best of their ability. That would be an implied contractual term in your employment contract. Within the first 5 days of starting your job, your employer must give you the core terms of your employment, and then within 1 month of starting your job, your employer must give you certain other terms of your employment in writing. So I'll chat through what those terms are that you should get within your first 5 days and within your first month in the next slide. So as I just mentioned, your employer must give you your core terms of employment in writing within the first 5 days of starting your job. And these terms that you need to get within your first 5 days are the names of the employer and employee, the employer's address, the place of work or where there is no fixed or main place of work, a statement stating where your various places of work may be, the date the employment started, your job title, grade or nature of the work. That's basically kind of like a brief job description. The expected duration of the contract. So if the contract is temporary or fixed term, the rate of method of calculating your pay and the pay reference period. For instance, are you paid weekly? Are you paid monthly? Are you paid fortnightly? Also, you need to be provided with what the employer reasonably expects the normal length of your working day and week to be. For instance, are you going to be working 8 hours a day, 5 days a week, Monday through Friday? Then you need to be told the duration and conditions relating to the probation period. And then also any terms or conditions relating to your hours of work, including overtime.
Just on the probation period, not all contracts, it's quite common to include a probation period, but it's not a requirement specifically to have one in every contract. Employers do tend to put them in. Yeah, so I'll just move on to the next slide.
Yeah, and then the remaining terms of your employment. So you are entitled to receive certain other terms of employment within 1 month of starting your job. And that can be your pay intervals. So again, if that is weekly or monthly, that you can request from your employer a statement of your average hourly rate of pay. You should also be told about paid leave, including your annual leave and public holiday entitlements. You should also be told terms relating to sick pay, if any, also terms relating to pension and pension schemes, the period of notice to be given by the employer or employee to terminate the employment, details of any collective agreements that apply, any entitlement to training provided by your employer. For temporary agency contracts, the identity of the person or the firm like hiring that agency worker. And then if your work pattern is mostly unpredictable, you should get information about the number of guaranteed hours and the hours and days you may be required to work and the minimum notice of a work assignment.
Before we move on to the next slide, Ronan, I just wanted to kind of, I suppose, pause there for a quick minute. So what Ronan has just run through is, it's the statutory entitlement to, the written terms of your employment. So that's, I suppose, one layer of, your employment contract related entitlements. So there's the employment relationship is kind of complex because I suppose while we're just looking at the statutory entitlements today, there's a few other layers just to be I suppose recognize and just to consider when you're looking at your employment relationship. So obviously you have the statutory one that we're talking about. Ronan mentioned implied rights earlier on, so these can come from the Irish Constitution and they can also come from case law. So these don't have to be set out in your employment contract for you to be entitled to them. So there's things like a right to earn a living, a right to a good name, and a right to fair procedures. So the extent of those rights, they're set out in case law typically. As well as that, you have rights under contract law itself. So where your employer has set out in the contract that you are entitled to a payment without any condition. Once there's offer, acceptance, and consideration there, you have a contractual right and entitlement to that payment. So that doesn't come from statute, it doesn't come from the Constitution, it comes from contract law. And then finally, Ronan mentioned about collective agreements there. So these can arise, for example, in certain sectors. So if you're a construction worker, there's a sectoral employment order that sets out certain minimum pay rates. I think it sets out certain terms to do with sick leave and pension contributions. So all of these layers, they apply to your employment contract and your employment relationship. So while we're just looking specifically at statutory entitlements here, it's good to keep all these other angles and facets in mind when you're looking at your employment rights and entitlements. So yeah, sorry, I went off in a bit of a tangent there. But Rhoda, yeah, if you wouldn't mind, I'll move on to the next slide then.
Yeah, thank you very much for that, Richard. So as Richard mentioned, your contract can include a probationary period. So from the 1st of August 2022, a probation period in the private sector cannot generally be more than 6 months. However, there are exceptional circumstances where your probation can be extended for further 6 months, generally up to a maximum of 12 months in total. So your probation could be extended where it is in your interests as an employee to have that probation extended, or where you have, for instance, been on extended leave, such as sick leave during your probation. In that scenario, then your probation period could be extended for up to 12 months. Then another thing that we want to bring to your attention are 0-hour contracts. So 0-hour contracts, they are used only in very limited circumstances, and those circumstances where 0-hour contracts can be allowed are if the work is of a casual nature, if the work is done in emergency situations, or it can be done for short-term relief to cover routine absences. So there are the three scenarios where 0-hour contracts can be allowed. And then
and sorry, Rhoda, just one point there. Just on the 0-hour contracts, in case anyone doesn't know, that's where you're not guaranteed any number of hours to work. It's where you are required to make yourself available to your employer. And so in the recent years, the government saw the issues related to 0-hour contracts that people were having, so they've limited their use to the categories that Ronan mentioned there.
Yeah, and then in terms of banded hours, so this happens where your employment contract does not reflect the number of hours that you actually work. So in that situation, you may request to be placed on a different band of hours. And in that situation, your employer determines what band of hours to place you on or to place you in. And then I can move on quickly to the national minimum wage and the living wage. So the national minimum wage for an employee who is 20 years of age or older is $11.30 per hour. However, you might have seen recently in the budget that as of January 2024, so as of next January, the national minimum wage will increase to $12.70. There are lower minimum wage rates that apply to employees under the age of 20. There is also the national living wage that you may have heard about in the media. And then a national minimum wage will replace it's hoped that will replace the national minimum wage from 2026. And the living wage will be set at 60% of the median wage in any given year. The national living wage is currently $14.80, but there is currently no obligation on employers to pay the national living wage currently. And the national minimum wage will remain in place until the national living wage is in place fully.
Okay, so this is where I take over then. So thanks, Ronan, for that. That was very helpful. Yes, so I'm going to talk about statutory entitlements relating to working time, annual leave, and public holidays. So these come from the Organisation of Working Time Act 97. It's been amended a number of times, and it's been around for quite a long time. But even though I suppose the employment world, how we do our work is changing, employers still have to comply with these obligations. So we've listed, I suppose, the kind of some of the main ones here that crop up for us. So employees are entitled to a 15-minute break when you work more than 4.5 hours, and a half-hour break when you work more than 6 hours. And this half-hour break can include the 15-minute break. And employers cannot require you to take that break at the end of your day or your shift, and that has to be taken during your day or your shift so that you get the benefit of the break. Then you've got a daily rest period of 11 consecutive hours in any 24 that you work, and a weekly rest period of 24 consecutive hours in any 7 days that follows the daily rest period of 11 hours. Alternatively, the employer could give you a 48-hour rest period in a 14-day period. The maximum number of hours that an employee can be required to work is 48 hours, generally averaged over a 4-month reference period. So that reference period can be shorter and it can be longer, but typically can be shorter or longer depending on the sector and type of job that you do. But typically your 48 hours is averaged over a 4-month reference period. So that doesn't mean that you can't be required to work more than 48 hours in any week. And for instance, I could be asked to work 60 hours this week, 52 next week, 45 the week after, and 49 the week after that. So it is possible for your employer to have you work more than 48 hours. It's just that the average, once you look at all of the weeks within the 4-month reference period, the average of those weeks working hours has to be 48 hours or less. And then employees required to work on Sundays are entitled to a Sunday premium. There's no rule or nothing from case law that sets a specific payment or premium amount, but it has to be reasonable. And if an employer has employees who don't work on a Sunday and then has employees that do work on a Sunday, there should be some difference that you can see in the wages that the employer can point to say that is the Sunday premium. Sorry. So there are some exceptions to providing these statutory entitlements to employees, but they're fairly limited. So one of the ones that we would see employers asking us about is where an employee determines their own working time. You know, what does that exactly mean? Because that can an employer who, or an employee who sets their own working time is not entitled to these many of the entitlements that we have listed here. But that only applies in a very, very limited situation, because an employee who determines their own working time really is someone who decides when they come into work, when they start, how long they work, how long the rest breaks they take. So you can see it's a very limited scenario where an employee would be considered to be setting their own working time. And specific rules then can also apply in certain job types and sectors, such as those we've listed here: doctors in training, people working on sea vessels, and in transport. So if this will move on to the next slide. Yes, so annual leave. So the amount of annual leave that you're entitled to, it depends on the hours that you work that are set out in your contract, or the amount of hours that you work in reality, if that's different to what's in your contract. So the Organization of Working Time Act sets out 3 methods for calculating annual leave, and you're entitled to the amount of annual, or you're entitled to, I suppose, to have your annual leave calculated using the method that gives you the greatest entitlement, if that makes sense. So method 1 is the one that we would most often see for full-time employees. So if you work at least 1,365 hours in a leave year, you're entitled to the maximum of 4 working weeks paid annual leave. So there's a few bits in that I just want to, I suppose, talk about. So the 1,365 hours, so breaking that down into 52 weeks, that comes to about 26 or 27 hours a week. So if you work that number of hours per week over a 52-week period, then you're entitled to this 4 working weeks paid annual leave. So a leave year, it can vary. It really depends on what the employer, I suppose, decides. We often see an annual leave year going from 1st of January to the 31st of December. Sometimes it's the 1st of April to the 31st of March in the following year. And then just the 4 working weeks, it's, I suppose, you'd often hear people saying, oh, you're entitled to 20 annual leave days, but that's not strictly, I suppose, correct. For me, I work a 5-day week, so I'm entitled to that 20 days annual leave. But if you were to work a 6-day week, you'd actually be entitled to 24 days annual leave, because your working week is 6 days, so you multiply that by 4 and that gives you your entitlement. So that's under method 1. Method 2, we don't see that coming up that often, quite frankly. So you calculate a third of a working week for each calendar month in which you worked at least 117 hours. And then method 3, we would often see used for part-time workers. So you calculate 8% of the hours that you worked in a leave year, subject to a maximum of 4 working weeks. So then in relation to public holidays, so for many, many years, we had 9 public holidays in Ireland. And then I think, was it last year or the year before, we got a new one, St. Bridget's Day. So that's the February date. So everyone's delighted. We now have 10 public holidays. So if you qualify for a public holiday, and sorry, I have them obviously all listed there on the slide. And if you qualify for a public holiday benefit, you're entitled to one of the following. So a paid day off on the public holiday, which we would quite often see, employers giving employees. But for some sectors, for example, retail, you might be required to work on a public holiday. So then you would be entitled to one of the other entitlements that are listed here: an additional day's annual leave, an additional day's pay, or a paid day off within a month of the public holiday. And it's for your employer to pick whichever of these benefits it wants to give its employees who qualify for a public holiday entitlement. So full-time workers are automatically qualify for one of these benefits. Part-time employees, I suppose there's a little bit of calculating involved. So long as the part-time employee works 40 hours in the 5 weeks prior to the public holiday, then you're entitled to one of the public holiday entitlements that are listed there. Employers sometimes give employees more than the statutory entitlement. So the statutory rules around annual leave, they apply to the, I suppose, statutory amount that you're entitled to. So you're 20 working days, for example. So anything above that would be subject to the contract law rules that I referred to earlier. So it's whatever is agreed in your employment contract with your employer to do with those additional annual leave days that are over and above your statutory minimum entitlement. Those are the rules that would apply. And then in addition to that, some employers give additional days off as company days. And one example is Good Friday. So it's not a public holiday, but employers often give it as a company day, and it's given at the employer's discretion. So, completely different topic now, employment equality. So this is, I suppose everyone's kind of aware, what's discrimination? It means treating one person in a less favorable way, than another person in a similar circumstance. And there are laws to prevent certain types of discrimination in the workplace. So the main piece of legislation is the Employment Equality Act 1998. And it protects against discrimination on the 9 grounds that are listed there: gender, civil status, family status, sexual orientation, religion, age, disability, race, and membership of the traveller community. So these, I suppose, the protection against discrimination, it's very, very broad. It runs all the way through the employment relationship, and even before the employment starts and after it ends. So you can see here we've listed a few examples. Recruitment. So there was a Ryanair case. It's old enough now, but it's a good example. Someone took a case against Ryanair because their advertisement for a job listed words that seemed to, I suppose, indicate that Ryanair wanted young and energetic employees, because the terms used, they used, I think, energetic, and I forget the other words now at the minute, but the long shot of it was that the employment tribunal, it found that this was a discriminatory advertisement because it discriminated against older workers, or older candidates, I suppose. So the protection against discrimination comes in around equal pay, training and work experience, promotion and or regrading, terms and conditions of employment, classification of posts, collective agreements, and dismissal. Another one that then it kind of comes in after employment ends could be if you're looking for a reference from your employer and they say no for some reason relating to one of the 9 grounds that are listed there. So one of the main grounds that we would see come up quite often for us relates to the protected ground, the disability ground. So disability in Irish employment law is defined very broadly. It's effectively any recognized illness or disability that someone, or a diagnosed condition. And an employer is required by law to reasonably accommodate that person who has a disability, to allow them access to employment, to carry out their work and undergo training. So this isn't an absolute right, it's a reasonable accommodation. So an employer is not required to accommodate someone where there's a disproportionate burden on the employer to do so. So what's reasonable and disproportionate? It depends on the circumstances, and there's a number of factors that the adjudicators might look at. For example, the size of the employer, the resources available to the employer, as well as the type of accommodations that the employee is either looking for, or a doctor or a medical professional has advised should be provided. So looking more specifically then at the workplace, so I suppose we just included this definition here of what is discrimination in the workplace, just to show how broad the protection is. So it's where a person is treated less favorably than another person is, has been, or would be treated in a comparable situation on any of the protected grounds which exist, which I've listed in the previous slide. So which existed, but no longer exists, may exist in the future, or if someone thinks a protected ground applies to a person. So you can see from that, it's a very, very broad definition as to what discrimination is. And a person can also be discriminated against because they associate or are thought to also associate with someone who comes within a protected ground. So the protection against discrimination is very, very broad. And then there's 2 types really of discrimination. There's direct discrimination, which is effectively someone being treated less favorably specifically because of one of the grounds. So where someone might say, we only want people between the ages of 20 and 35 to apply for these roles. That would be a form of direct discrimination because it's discrimination on grounds of age. Indirect discrimination is a little bit more difficult to, I suppose, see, and it really comes through on the implementation of a particular practice or policy. So while a practice or policy could look, completely fine on paper and doesn't show up any issues from an equality perspective, when it's implemented, it could then show that in fact it is discriminatory in reality. So an example might be where an employer only gives full-time workers a particular benefit. And while that might look fine on paper, it doesn't relate to specifically any of the protected grounds we've talked about. But if there are part-time workers in the employer and all these roles are filled by women or predominantly women, then it's indirectly discriminatory on grounds of, potentially on grounds of gender. Indirect discrimination can be justified on legitimate grounds if it is proportionate. What is proportionate and what the legitimate ground is, again, it depends on the particular case. But what is proportionate, it has to be, necessary in the circumstances and only goes so far as is needed to achieve the relevant aim. There are a few exceptions then to I suppose there are a few exceptions where discrimination can be permitted. One of these is where a particular characteristic related to gender is, I suppose, required for a particular job, and then that limits access to employment. So the characteristic, it must be a genuine and determining occupational requirement. And again, the objective, it must be legitimate, and the requirement must be proportionate. So one example might be that we've given here, the guards or the prison service assign a task to certain, either men or women, for example, carrying out searches, for example, body searches. Another example of an exception is that it is not discriminatory in itself to set a mandatory retirement age. But again, that retirement age must be objectively justified. It must have a legitimate aim, and it must be proportionate. So employers can find it difficult to, I suppose, succeed in applying this exception, because retirement ages, maybe they've been historically in place and no one has considered, well, why do we still need it? Do we actually still need this retirement age? So they're just some of the exceptions then. Next then is the is the dismissal framework. So in Ireland, under the Unfair Dismissals Act 1977, Irish law provides for protection against unfair dismissal. So this protection usually applies once an employee has 12 months service, but there are exceptions, and we've listed a couple of them there. So where dismissal is in retaliation for making a protected disclosure, or where the dismissal relates to an employee's pregnancy, you don't need the 12 months service to avail of the unfair dismissal protection. And then also, I suppose one other point to mention is that there are two aspects that an employer has to show in order for dismissal to be fair. So one is that we've listed here, the reason for the dismissal must be fair. So the Unfair Dismissals Act sets out 5, I suppose, categories of reasons to make a dismissal fair. And the employer has to be able to show under which of these categories the dismissal fits or falls. So you can see there, the dismissal in relation to capability, competence, or qualifications can be fair. Dismissal related to conduct or redundancy can be fair. Where the employer was prohibited by statute from continuing to employ the individual, that can be fair. So for example, that could come up where someone no longer has permission to work in Ireland. And E, I suppose it's a catch-all. There must be substantial grounds justifying dismissal. Sorry, I just need to wipe my nose, which everyone is delighted at seeing. But anyway, so yes, so you've got your fair reason, so that's one of them. But then you also have to have a fair procedure. And like I said at the start, this right comes from the Irish Constitution as well as kind of from case law. So this is implied into your employment relationship. So where, for example, you're being made redundant, the fair procedure right requires that the redundancy process be fair. It relates to your role and it doesn't relate to you. And a process needs to be applied. So this would usually require the employer to put you at risk, that your role is at risk of redundancy, and to have a meeting or two with you to set out the proposal to make your role redundant, and to give you an opportunity to provide feedback and to comment on the proposal, and to put forward any other alternatives that you might consider. The employer then looks at those, considers all the information that has come from those meetings, and then has a confirmation meeting to let you know whether your role is continuing or whether it's going to be made redundant. Then in a conduct-related dismissal, fair procedures, there's certain rights, that the person subject to the disciplinary process of an employer that person has. So these include, you're entitled to know the allegation made against you, and that you have an opportunity to effectively state your case. So what fair procedures requires, it depends on the circumstances. Then, so that's, I suppose, fair procedures, unfair dismissal. Separately then, you have protection against discriminatory dismissal, which links back to the equality slide that I was showing you there. So you are protected from dismissal on any of the 9 grounds that I had listed previously in the slide. And there's no minimum service requirement for that protection. But where you are entitled to bring an unfair dismissal claim and or a discriminatory claim, you have to elect between either of those. You can't bring both. You have to either pick the unfair dismissal claim or the discriminatory dismissal claim. So that's the dismissal framework. Then just to quickly run through avenues to address workplace issues, complaints, or disputes. So if something arises in your workplace and you want to address it or try to address it, your employer will typically have policies in place. This isn't usually a statutory obligation. It's more best practice for employers to have these policies, or most of the policies, in place. So you could bring a grievance because an employer will usually have a grievance policy, and you'd really just be complying with the rules set out in that policy. Then an employer would often usually have a disciplinary policy, and it would often list your rights and entitlements in a disciplinary procedure. And then also there's bullying and harassment policies that employers tend to have in place as well. They don't tend to have contractual force, but sometimes they do, so it's worth checking that out. Next then, so if you were unable to resolve your issue internally, or whether you just didn't want to try and deal with it internally at all, you can bring a claim for breaches of most of the rights and entitlements that we have spoken about today. You can bring a claim to the Workplace Relations Commission. So the Workplace Relations Commission is the Irish Employment Tribunal. It's set up under the Workplace Relations Act 2015. And yeah, so if you have a claim, you can bring it, and it will either be mediated if both parties agree to it, or an adjudicator is assigned to the complaint if either party doesn't want it to be mediated, or if mediation is unsuccessful. Typically for an adjudication, there's one person sitting, and it's effectively, well, it's a hearing. So one side will go first, then the other side will go, and there might be witnesses, there could be legal authorities that you want to mention, and then the adjudicator would decide on what the decision is. These hearings are usually in public, except in exceptional circumstances, and the decisions are published on the WRC's website. I suppose one important factor, and it'll become relevant once we go down through the rest of the slide, but one important factor for why employees go down the WRC route is that parties bear their own costs. So whether you win or lose, you bear your own costs. So how to make a complaint to the WRC? The form is available online, and then you would usually just email it into them. You'd usually have 6 months from the date of the relevant breach to bring a complaint to the WRC. And this time limit can be extended by 6 further months, but there must be a reasonable cause for your delay in bringing the claim. and the WRC can be quite strict on, determining whether the cause for the delay is reasonable and whether to extend your time limit to bring a complaint. So it's really important to be proactive if you do have an issue, and if you're considering submitting a complaint to the WRC, to do it well in time. So so after the WRC hearing and you get your decision, you're not happy with it, you can appeal to the Labour Court. So within 42 days from the date of the WRC decision. And the Labour Court sits in a panel of 3. It's a little bit more formal than the WRC, but it's less formal than the civil courts. So there is an appeal from the Labour Court, but it's on a point of law only. It's not a rehearing. The appeal to the Labour Court from the WRC tends to be a rehearing, whereas the appeal to the High Court, it's more that, I don't know, you think that the Labour Court misinterpreted a piece of legislation, for example. That's where you might appeal to the High Court. Then finally, the other avenue is via the civil courts. So that's the District Court, Circuit Court, High Court. Usually this would be for breaches of contract or personal injury type claims. The civil courts don't tend to consider claims related to breach of statutory entitlements because the way they see it, the government has set up the WRC specifically to deal with these types of breaches. So they don't tend to get involved in those unless you have your appeal from the High Court, like I mentioned before, or appeal to the High Court from the Labour Court that I mentioned before. So civil court proceedings tend to take longer and they are more costly than WRC proceedings. And the losing party is also at risk of having to pay the winning party's costs in civil court proceedings. So that is one of the main reasons, or these are the main reasons why we would often see employees bringing WRC complaints rather than going to the civil courts. So yes, so I'll hand back over to Ronan, who's going to briefly run through some results.
Thank you for that, Richard. So here we just have some useful resources that you can access to find more information on any of the topics that we've discussed here, or just about employment law in general. So if Talita has shared the slides with you, you should be able to click into these links because they're all hyperlinked. But I'll give you a very brief whistle-stop tour as what you should find in each one of these. So the Workplace Relations Commission that Richard mentioned earlier, the WRC, that has different codes of practice and general information on employment rights, as well as previous decisions. The Labour Court also has previous decisions and also policies and procedures. The Citizens Information, here you can find a lot of information on your employment rights and other related employment matters in general. The Law Reform Commission, that contains a lot of consolidated versions of the employment law legislation, the Employment Law Acts. The courts.ie, that's where you can get, also you can find some employment law decisions there that have been issued by the courts in Ireland, as well as some practice directions that the courts issue. The Irish Human Rights and Equality Commission, that also has some codes of practice, as well as information on your employment rights and just your rights in general. The Department of Enterprise, Trade and Employment, there you can access a lot of helpful information on employment permits. And then the Department of Justice, you can get a lot of information there. Quite usefully, you get a lot of information on residence-related immigration matters. And then finally, the Irish Statute Book, that is where you can access all the legislation in Ireland. So if you wanted to access employment legislation, if you come across a specific act, then you could look that up on the Irish statute book as well. And that's quite useful if you want to just do a little bit of research or digging yourself.
Yeah, so the Law Reform Commission, it hasn't consolidated all of the employment acts. It has consolidated, I suppose, the most commonly used ones. So the Irish statute book is where the full list of legislation is provided, but it can be a little bit tricksy to look through. So that's why we mentioned the Law Reform Commission here. And yeah, the WRC and the Labour Court slides or links, the practice and procedures that they set out, they're to do with their complaints procedures and how they deal with the complaints when they receive them, how adjudications and how hearings are run, that kind of thing. But yeah, so that's it. I hope it was a useful presentation. I know there's a lot of information there to digest. Again, it's only a snapshot of the statutory entitlements that are out there. The WRC has a lot of information on generally on those kinds of entitlements. So yeah, so if you have any questions, we're more than happy to deal with them now. I think we have a few minutes before 12. Otherwise, if you have questions now or you think of some later on, I think if you send them on to Lita, might be the handiest thing, and then we can address them that way either.
Thank you so much, Richard and Ronan. That was very useful. I know I learned a lot. I might just actually stop recording. So if anyone wants to ask a question but doesn't want to be on the recording, so just gonna stop that.